I have nothing. I don't have an advice of rights. I don't have anything.
All right, I have it. I thought that I had sent it in. If we could pass the matter and I could try to send it in again, I would appreciate it.
What are you doing with, is that resolve both cases?
No, Your Honor.
I thought that we had worked out he was going to be pleading on both with an agreement to time served.
Okay, folks, what am I doing? Hang on. Are you being held on something else other than these?
Yes, Your Honor, he is.
He's talking to me right now, Robert. They said that you supposed to rule whether I can go to treatment because they want me to have a tether, and I'm not gonna run.
Hold on.
Oh,
What's that on?
huh?
Is that on another case?
No, that's on this. This he's supposed to be talking about that too. He's supposed
Hold
to.
on.
Your Honor,
Hold on,
Mr.
I gotcha. I'm just trying to figure out something.
Oh.
Or any illegal drugs. I will also order, ma'am, that you are not to go to any Kohl's store in the state of Michigan. You understand that?
Mm-hmm.
Is that a yes?
Yes.
Anything further?
Nothing further, Your Honor. Thank you.
Thank you. Thank you, ma'am.
So,
Thank you. I'm allowed to leave now?
Yes.
Cool.
Court does call the case. People versus Leandra Hardesty.
Good morning, Your Honor. For the people.
Good morning, Your Honor. Dan Garrett on behalf of Ms. Hardesty stepping forward. State your name, Leandra.
Leandra Hardesty. Oh, sorry.
Your Honor, for arraignment purposes, we'll waive and mute, please.
Been arraigned.
Oh, she has.
Yeah.
Well, even better. I take all that back.
Very efficient.
Your Honor, Mr. Cook and I have had some discussions. We're asking for an adjourned pretrial for Ms. Hardesty to do some things behind the scenes. So if Your Honor would give us 4 or 5 weeks to get those things done. Yes, maybe 4 weeks.
Anytime. Okay.
June 3rd?
That seems like
That's like 8 weeks. 6. That's like 4. That's it, right?
that's the perfect spot. Yeah.
It's okay.
We thought you had a vacation. And then that wasn't likely.
Apparently, I'm taking a month off. I don't know. May 6th, 2026, 9 a.m. Continue. What was? Okay, sorry. We'll talk later. Court does call the case of the people versus Joshua Waara.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Judge Lawrence Margolis with Mr. Waara. Josh, please unmute yourself and state your name.
Joshua Waara.
How you doing, Mr. Waara?
Good, and you, Judge?
I think I'm doing okay. All right, where are we on this case?
So this is, I think, set for a competency hearing today. He was found competent. Mr. Cook and I are in discussions for a global resolution. Josh has several cases in this county, and we're hoping to get them all resolved. We're asking for 2 to...
I don't have... Do you have me set for a comp hearing?
So,
I think it's set as a pretrial. I think the comp came in another case because I don't have a report.
Okay. We'd ask for a short adjournment. We're going to try to wrap everything up. Josh is doing well. He did 2 short hot
Will
short.
Will April 15th work? Or you need something like in, I don't know what month she's giving me, like August? No, I'm kidding.
April 15th, I'm actually leaving town to go visit my daughter in Spain. If anything, 2 weeks after that would be wonderful. Or, yeah.
May 6th. Will May 6th work? Apparently that's the day.
It will for me.
All right. May 6th, 2026, 9 a.m.
Thank you, Judge.
All right, Mr. Waara, take care of yourself, fellow.
Thank you, Judge.
Thanks, Josh. We'll talk. Bye.
Court does call the case of the people versus Paul Waara.
Your Honor. Raymond Cook for the people.
Joe Simon on behalf of Lawson, who's making his way to the podium.
And state your name, Paul. Good morning, Your Honor.
Morning.
Paul Lawson. We reached a resolution.
I haven't said anything.
Honestly, I was waiting for,
No, I said to myself, there's Simon. I'm not gonna say anything bad.
I almost cautioned my client. I forgot that my height would be referenced today, or lack thereof would be
Your
referenced.
lack of height,
Yeah.
how much different? Or we painted you blue, you would have looked like a Smurf. But
Oh. Okay.
I don't even know why I went there. But
I don't know. It's crazy. Anyway, you have a plea sheet in front of you, Your Honor. I think we've reached a.
I do. Plea sheet indicates that the defendant is going to be pleading no contest to the charge of assault and or assault battery, 93-day offense upon his successful plea. That's the stated count.
Yes.
He'll be pleading to the stated count. There's a sentence agreement. Prosecutors deferred with no upfront jail. That's the court's full understanding of the agreement.
That's correct, Your Honor.
It is, Your Honor.
May I have him sworn?
Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Good morning, Your Honor. Paul Watson.
Sir, it is this court's understanding that you're going to plead no contest to the charge of assault and or assault and battery. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. Do you understand that, sir?
Yes, Your Honor.
All right. Do you understand what a no contest plea?
Yes, Your Honor.
All right. Two things about it. I have to make sure that you understand. It first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that? All right. Basis for the no contest plea.
Potential of civil liability.
Sir, to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Your Honor.
Signed in advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up, or pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
Doing this voluntarily and of your own free will?
Yes, Your Honor.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2521378. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. And that's sir.
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
None.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Or will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
April 29th at 12 noon.
April 29, 2026, noon.
What's wrong with that? Okay.
Bond with its conditions will continue.
Thank you, Your Honor.
Thank you. Sir, you're welcome, sir. Make sure to stop down at probation. They're on the left-hand side.
Meet with your son. Okay, fine, sorry.
Court does call the case People versus Merrill Snider case.
Look for the people.
Your Honor, Joe Simon standing in for Mr. Chris Eastoe, who is the attorney of record for Mr. Snider case. State your name.
Morning, Your Honor. Merrill Snider case. Don't have any problem with Mr. Simon's step.
No, Your Honor.
All right. As to the arraignment,
Wait, formal reading stand mused.
and then waive formal readings, the court will enter a not guilty plea.
Regarding the pretrial, Your Honor, Mr. Eastoe spoke with Mr. Cook. He's requesting a lengthy adjournment so that my client can get his Mr. Eastoe's client can get his status hopefully remedied by the time we return to court. That June date that I heard announced earlier, I think would work.
Wow. June.
Well, I thought I heard a date in June. I'm sorry.
That was kind of an error.
Whatever the court deems, Your Honor.
How much time is he gonna need to
Come on,
do it?
yeah, I'm done.
That's 6 months. What? Do you think?
Well, I mean, will it take all of that?
45.
45 days, he's saying it would probably take.
What was that date you gave us wages for June what? June 3rd, 2026. 9 a.m. Bond is set at 5,000 PR. Standard condition, including no assault, ever possession of weapons. Thank you.
Thank you, Your Honor.
Thank you, Your Honor. You're welcome.
All right, wait for me outside, please.
Court calls case People versus Ariana Banks.
Our Assistant Public Defender Constable, on behalf of who's present by Zoom. Ms. Banks, can you state your full name for the record, please?
Ariana Banks.
You turn on your camera, please.
Oh, yes, sorry. Is it on? I can't see.
Got it. No, we can see you. Hello.
Okay. Hi.
There is the entire pre-trial on this matter. We're going to be requesting an adjournment. There is an offer. Need some time to finalize that offer. Maybe solutions. We'll ask for about 2 weeks.
Pre-trial on this matter will be adjourned April 15th, 2026, 9 a.m. Bond will continue.
You
All
said
right, thank you,
April
Ms.
15th?
Yes, ma'am.
Okay, thank you.
Thank you. Court calls case of the People versus Carlton Cross.
Raymond Cook for the people.
Assistant Public Defender Constable Lacey on behalf of Carlton Cross.
Not checked in.
As I understand it, my client is currently in treatment. We did send them
Hello?
over the Zoom.
Hello.
Hello, my name is Carlton Cross.
Here.
Thank you.
You're welcome.
We're going to be requesting an adjournment to track some other cases. My client has to be asked for a date past the 7th of April. My client has a hearing with Judge Conkey at that time.
He's what?
Just track what's going on with his felony cases. So we just asked for an adjournment for past April 7th.
I had a sobriety court. I thought they were trying to get him into sobriety court.
That's correct.
Trying to get into felony sobriety court or have this come along, or what are we doing?
Information I have is he had the hearing on April 7th with Judge Conkey, and I believe that
I'll adjourn it to April 15th, 2026, 9 a.m. All right, sir.
Thank you, Judge Simpson.
Thank you, sir.
Yep.
there you are.
Court calls case People versus Otis Elliot.
Assistant Public Defender Constable Otis Elliott.
Sir, can you state your name?
Otis Elliott, sir.
Thank you. What are we doing?
We're requesting an adjournment to get some possible mitigating information.
It's my date after. May 6th?
Yes, sir.
Sure.
Very sure.
During the matter, May 6th, 2029 a.m. Bound continues. Oh, I didn't know you were there. I couldn't see you. I didn't know you. I felt unsafe. For another brief moment, I felt unsafe. It was on you, and I had to do something. Court calls the case People versus Javon Foster.
Your Honor, Raymond Cook for the people.
Public Defender Constable Lacey on behalf of Von Foster.
Hello?
Hello? Can you hear me?
Yep, we can hear you.
I'm sorry.
See you. We're
Okay.
good. What's your name?
Jovan Foster.
Thank you. What are we doing?
Your Honor, we're requesting an adjournment for good
Of course
conduct.
you are. What? Go ahead.
We haven't been able to contact Mr. Foster, so
Right here.
I would like him to contact the public defender's office and give us some good contact information. Mr. Foster, can you take down this phone number and please call them and update your contact?
Yeah,
info?
I got it's all of my stuff is still the same. My phone was just off. I just paid my phone bill last night. I'm
You need
sorry.
to call them, make sure that they have the information, okay? You
Okay.
got something to write down, a phone number?
I got all the information. My phone was just off. I just had to pay my phone bill.
Oh.
Understood.
Yeah, I literally just paid it last night. I'm sorry.
You paid it last night?
Yes, sir.
So it's on?
Yes, sir.
All right. April 15th, I'm good.
Thanks.
Bond continued. Thank you, sir.
Thank you.
Okay. Just checking. Court calls the case, people versus Tony Gomez.
People?
Lawson Gomez on behalf of Tony Gomez, Your Honor. Gomez, could you unmute, state your full name for the record, please?
Tony Gomez here. Good morning, Your Honor.
Today's set for a
Good morning, sir.
matter. Going to be requesting a short adjournment. My client sent him the questionnaire to fill out, and he's hoping to get into the Dearborn Veterans Court. We sent him over the DD 214. We just need to get that.
So that hasn't, so has he not been accepted? I thought he was accepted already.
Mr. Gomez, were you accepted into the court? I know that we sent you the information in the packet to fill out. Did you get?
Yes, so what I understand is that I am to be accepted, and the only thing that has to happen is Judge Simpson, Your Honor, you have to submit your sentence on your end, and then I go over to their side.
Right, that's what I thought was occurring,
Right.
that he has not as of yet entered a plea. And that he was going to plead to this charge. I think he was going to do a no contest plea. I was then going to sentence him with probation or supervision through the Veterans Court.
So we would then just ask for the briefest of adjournments to get the plea finalized, Your Honor.
Get the plea finalized? I have it.
Has the plea for.
I know, I've got everything. I'm just trying to get Mr. Gomez on his way. Mr. Gomez,
Yes, sir.
when are you supposed to start in the Veterans Court? Have they given you a date?
No, Judge.
Because they're waiting on us, but I don't even have. Part of my problem is I don't have the MOU. I have the plea, but I don't have an MOU. I don't have any. All right. Does your file reflect that an MOU has been signed off by anyone?
By like.
All right. Well, look, folks, Mr. Gomez has been waiting for us. Well, not us, you guys, to get your act together. I've got mine together. So I'm going to adjourn it to the 15th. I'm sorry about that, Mr. Gomez. I thought we were all set, but I see that I don't have some paperwork for whatever reason. I'm going to adjourn it to the April 15th, 2026, 9 a.m. Let's get everything together, make sure the MOUs are signed off if we need them, and just get this done. All right.
Yes, Your Honor. I'll make sure that gets done.
All right, sir. Thank you.
Thank you, Judge.
Court calls case, People versus Nia Hall.
Your Honor, Raymond Cook for the people.
This is public defender Natalie Pate with on behalf of this court, present via Zoom.
Ms. Pate, it's great to have you back.
Back,
Is it?
yes. Especially on a great holiday.
For Fool's Day? Okay.
Joel's. Having Fool's Day.
No, we're not. We're not going there, Ms. Pate. All right, let's go. All right, what are we doing? Have to unmute, Ms. Hall.
Oh, excuse me, sir. Nia Hall.
Thank you. She was talking, but I couldn't hear.
Thank you, Your Honor. So Mr. Cook did extend, or the people did extend an offer yesterday of retail fraud third degree last night. I need an opportunity to fully discuss that and finalize with my clients. I'm asking for a brief adjournment.
April 15th, 2026, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you, Ms. Hall. Court does call the cases of the people versus Shannon Kiesling.
Your Honor, Raymond Cook for the people.
Lawson will on behalf of Shannon Kiesling, Your Honor.
Same.
Full name for the record, please. Just state your full name for the record.
Shannon Kiesling.
Thank you.
Yes, Your Honor, today is the date and time set for a pretrial. There is an offer being discussed in this matter. We would just ask for one final adjournment to finalize the offer.
April 15th, 2026, 9 a.m. All right, thank you. Court calls case, people versus Austin Knox.
Your Honor, Raymond Cook for the people.
This is probably kind of good of the page between staff and Mr. Knox. You should be present on Zoom. Sir, can you please state your name for?
Austin James Knox.
Thank you, Your Honor. I was able to confirm what the current offer is with Mr. Cook last night. He did extend an offer where my client could plead to 2 of the counts and 2 of them would be dismissed. I'm asking for one final.
April 15th, 2026, 9 a.m. Court calls case, people. Thank you, Mr. Knox.
Thank you.
Court calls case of people versus Aaron Lawson.
Your Honor, Raymond Cook for the people.
When Your Honor, this is Public Defender Constable Daisy on behalf of Mr. Aaron Lawson. Mr. Lawson, can you state your full name for the record, please?
Aaron Lawson. Thank you. I should have said that, to be honest. Not really. What? Yes.
Your Honor, today's the date and time set for a pretrial in this matter.
It's good to see you too, Mr. Brumpies. I didn't want to
Is that part of
show any favoritism.
that part of the April Fool's?
Oh, no, I didn't want to show any favoritism, although I like Pate better. Go ahead.
Your Honor, we're just going to be requesting the briefest of adjournments in this matter to come to a resolution in this case.
Is he trying to get his license back?
He was trying to get his license back, Your Honor. He just received some information yesterday that was not the best regarding that. So it looks like we're just going to be taking the offer at the next court date.
Is the 15th going to be enough time for you to figure it out?
Yes, Your Honor.
Stay.
No, the 15th should.
15. April 15th, 2026, 9 a.m. Bond.
Thank you, Your Honor.
Thank you. Court calls case, people versus Raymond Lee.
Your Honor, people. And Conrad Solar on behalf of Pittsfield Township.
And Assistant Public Defender Natalie Tate with an on behalf of Mr. Lay, who stands to my right. Please state your name for the record, sir.
Raymond Lee. All right. We've got one issue on this case.
Yes, Your Honor.
Which my staff gave direction, and Mr. Sellers seems to disagree with my conclusion. No, go ahead. Say what you're gonna say.
Your Honor, I think it's just a mere scrivener's error by the officer.
No, it may be, but so that it's clear that the ticket, it was entered as a state case. It is supposed to be a Pittsfield case, according to Mr. Siller, and I don't have any reason to dispute that. But the ticket as issued, officer, I'm going to look for the boxes. There's boxes that they can check, indicating what they're in violation of. The box that's checked is state law. Mr. Siller's indicating that it should be local ordinance.
That's absolutely.
the clerks entered the ticket properly. It can't be changed unless the ticket is changed. The other way the ticket can be changed is for the ticket to be reissued, what I guess could do it and amended, or to dismiss this and reissue a ticket under local ordinance. That's the other way to correct it.
If the court were to find that it's merely Scrivener's error.
Face.
I'm not do it because the clerks entered it correctly. I mean, I don't know it to be a Scrivener's error because the section is the same. I can't say that because Pittsfield can write them either way.
Except it's against their policy and they don't write them this way in school. You know that, and I know that.
Well, I don't know that for sure. I don't because we have tickets that are written by Pittsfield under state law. I mean, maybe not this kind.
But not for you.
Well, I'm not doing that. My clerks edited it correctly as it's presented, so it's either going to have to go one way or the other.
Your other people would move to dismiss at the time, so it can be refiled appropriately.
All right. Well, okay, so now here's going to be the problem. And the problem really is, before I grant that, Mr. Lay, can I get a new ticket? I mean, because otherwise what's going to end up happening is he's here. He's going to have to come all the way back from Ann Arbor.
Actually, I'm in South Lyon now, Your Honor.
South Lyon?
Yes, sir.
On purpose? No, I'm kidding. Don't answer.
On purpose.
All right. So it's going to be, I mean, I get that it would be reissued. It's going to be reissued. I prefer just to put it out, get the ticket reissued and just have him come back at 1, or he's going to have to come back in if anybody's following what I'm saying.
Well, I don't know how we get the ticket reissued in that short amount of time. My plan is I was just going to file a complaint, summons, and then clear the whole issue.
Tonight. Folks, he has another ticket from 2024 for the same charge that is properly written under local ordinance. I don't know if you're aware of that.
And that's an open case, Your Honor?
Well, it's actually in warrant status. I was going to have to do something today with it. So there already is a 2024, and it's the case number on that. It's 24-1-0399, which is a driving while license suspended, written by Pittsfield, written under the local ordinances check. So it's written under local ordinance. So I don't know if that changes anything in terms of what we do today or not.
Given that, Your Honor, I believe Mr. Laywood's wanting to have the same resolution possibly in that 2024 case as to the other ones. Awesome.
I think we have it resolved.
What are we doing?
On both cases.
Okay, what are we doing?
So, Your Honor, as to the 241-0399 case, Mr. Siller graciously offered double parking, civil infraction, to which Mr. Lay would like to take.
That's correct.
Double parking on the 24 case.
On the case.
What are we doing on the other case?
We'll still be discussing.
And no objection.
Wait, he doesn't. Although he really watched it.
Had a great time.
Huh?
Had a great time.
It's been a blast. So on that case, technically, I have to cancel his warrant.
Bless you.
Who did that? Yeah. Okay, bless you. Got no way, everybody. Cancel his warrant in that case. And then, as technically, I guess then as to the arraignment, you're waiving formal reading.
Wait for my client stands mute.
And then every waive formal reading, standing mute. Court will enter a not guilty plea as to that charge of driver while license suspended. Sir, do you admit responsibility to the fact that on March 24th, 2024, the location of Hogback Road in Pittsfield Township, Washtenaw County, State of Michigan, that you double parked a motor vehicle? Correct. All right, court will accept that admission to count 2. Count 1 is dismissed. Also, I don't think it's part of the plea agreement. Case ending in 0156 is also dismissed by the people. Fines and costs of $180. When can you get that paid, sir?
I can pay it today, Your Honor.
Oh. And it today, and he's from South Lyon and everything.
See?
All right.
Line ain't that bad.
Okay. All right. Had you been in Ann Arbor, we would have been waiting. All right. Pay that today, sir. Out at the county. File of the house. You have a great day.
You, sir.
Thank you, Your Honor.
Thank you.
Court calls the case. People versus Elizabeth Loman.
Morning, Your Honor, Raymond Cook for the people.
Hello, Elizabeth Loman.
And this is really kind of on behalf of Ms. Loman, who's already stated the name. To have a direct conversation with Ms. Loman yesterday, and I was last night able to confirm what the current offer was. I do appreciate Mr. O'D with us some navigating through files, information in different places. Long story short, I'm respectfully requesting adjournment. There is a potential resolution that I think will happen at the next pre-trial.
All right, Ms. Loman, I'm going to adjourn your case April 15th, 2026, 9 a.m.
Okay.
Bond will continue. All right.
Thank you.
Thank you. Court calls the case of the people versus Elijah Juan Matthews.
The people.
Good morning, Your Honor. Constable J.C. on behalf of Mr. Matthews.
Sure. Elijah Juan Matthews, not here.
Your Honor, I know we were still looking for the video from Meyer in this case. My notes indicate that we have not gotten that video yet, so I was going to be requesting an adjournment on that client. Who is not here.
And for the record, Your Honor, that video has been marked and should be sent over, if not by the end of the day today, very shortly.
All right. So they'll find the video and then you got to find your client. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. I'll give it 10% privilege. That warrant will issue immediately. You're welcome. You mean that?
10% privilege part?
No, that's what you were thanking me for? Well, B, so this is gonna be a long day. You keep that. Court calls the case, people versus Mark Macintosh.
Raymond Cook, people.
Public Defender Natalie Pate with and on behalf of Mr. Mac. Name for the record, sir.
Mark McIntosh.
Thank you, Your Honor. So Mr. Macintosh is currently,
Whenever Pate starts out, so
it's all good.
go ahead.
It's not so he's like doing his violations, but here's his reason. No violations. So Mr. Macintosh is doing drug treatment court in Monroe County. Right now he's completely in compliance and doing well. I was able to confirm the offer last night for Mr. Cook, which was retail fraud third with an agreement to any restitution requested, and the people would not object at sentencing to an offer of fines and costs. I believe that that's a resolution that will be happening. We've been in talks for our office and the people. So I'm asking for one last adjournment to nail this down.
Is the only thing just that you don't have the paperwork in?
Largely, yes.
Right.
It was after I spoke to Mr. Macintosh that I was able to get the offer confirmed by the people last night, what it was. Mr. Macintosh informed me, which I'll be candid, I could not locate the offer in the file I had. Mr. Macintosh informed me he thought it was a retail fraud third, and I was able to Cook last night.
It's a long story.
It is.
I was just gonna get, go ahead, I'm listening.
It is. So what Mr. Macintosh said was correct. I just didn't have it in the public defendant file, unfortunately. It was not in any notes or anything. And then Mr. Cook was able to, and it was Mr. Cook confirmed it.
All right, so listen. All right, let me just stop you. If I pass this case, since Mr. Macintosh is down here, and you guys put the paperwork together and I call it up in the next block, we can get this gentleman taken care of.
That would be quite miraculous. I would love that, Your Honor. Thank you.
You are? Because you knew where I was headed.
That's miraculous.
You know what? I think you knew where I was headed and stalling for time. So she was just gonna talk to me.
I was, because I thought it might be better instead of I just kept talking until it's like, whoa.
Until all of a sudden you had no choice, Judge. All right, that's what we'll do. Will that be okay with you, Mr. Mac?
Yes, sir.
All right, that way you don't have to come back. So have a seat. They'll get that together, get it to us, and then we'll call you up at the next block. Thank you.
Thank you very much, Your Honor.
Thank you. Thank you, man. Clerk calls the case. The People versus Prince Rashawn Logan Cannon.
Morning, Your Honor, Raymond Cook for the people.
He has no counsel on it.
Much better. Okay.
Your name, sir?
Prince Rashawn Christian Logan Cannon.
Are you chewing gum?
Yes.
Thank you, sir.
Sorry about that.
No, it's okay. Says you're not represented by counsel, but this is your request.
Yes.
Have the people seen this?
Your Honor, I did not see that I ever received the file of motion. I looked in the RFA and it said it was, I believe it was mailed to our office, but I was unable to. As a copy that I could, you would greatly appreciate that.
All right, here's what I'll do, because they've got to look up certain things. I'll do the same thing I was doing with the other one so that you don't have to come back. We'll get him a copy, they can look it over, and then I'll call your case back up in my next one.
I appreciate it.
Very good. Fair enough. All right. Can we make sure that Mr. Cook gets a copy of that? That's it for that block. Is the jail up yet or no? They are? Okay, then I'll take a brief recess. I'll come back out. We'll begin calling our 10 o'clock block. What are we doing with, is that resolve both cases?
No, Your Honor.
I thought that we had worked out he was going to be pleading on both with an agreement to time served.
The other case is new, just recently charged. I was just newly appointed late last week.
Okay, folks, what am I doing? Hang on. Are you being held on something else other than these?
Yes, Your Honor, he is.
He's talking to me right now, Robert. They said that you supposed to rule whether I can go to treatment because they want me to have a tether, and I'm not gonna run.
Hold on.
Oh,
What's that on?
huh?
Is that on another case?
No, that's on this. He's supposed to be talking about that too. He's supposed
Hold
to.
on.
Your Honor,
Hold on,
Mr.
I gotcha. I'm just trying to figure out something, Mr. Peterson. If I put this out 2 weeks for them to get everything together, does that stop you from being released? I don't think so, because you've got something else pending, right?
Stop me from going to treatment.
Well, hold on. Are you held on any other cases?
Just
Yes,
these.
Your Honor, he is.
So he's held on other cases?
Yes, Your Honor, he has 2 felony matters in front of him, Your Honor, that he's being held on as well.
That are set for PCC.
Yes, Your Honor.
And so what I also hear, okay, so here's what I'm going to do. Okay, Mr. Peterson, I'm going to adjourn these out to the 15th. And 2026, 9 a.m. Okay. Both of these cases. They can get their paperwork in order, get that all to me so we can then resolve these. With regard to release to treatment, is there on his felony matters and otherwise, is there going to be any objection from the people?
I thought we'd already ordered. the
We
release.
we submitted orders, Your Honor.
Okay, then that's all taken care of. Okay, so that's been done. Okay, on these cases, if these are holding him, I'll need orders for that on these cases. But on the felony cases, they've got it all set.
All right, thank you.
All right. So we'll see you in a couple weeks. All right, Mr. Peterson, take care.
Thank you, Your Honor.
Court calls the cases of the people versus Justin Randolph.
Morning, Your Honor. Bring for the people file 0556.
So on behalf of the township and 0040.
Probably under name for Mr. Randolph, but unfortunately, I do not believe.
I did that. That me? No, I think it was him. Sunglasses. Yeah, he got them all worked. No. All right, what are we doing on these? Is he here?
I don't think so, Your Honor.
He's not checked in.
I offered the report is that I don't have great contact information for him, and I do have him on another case elsewhere, in which the only phone number I had was that.
He's got bond violations though?
I was not able to hold him discuss that with him, so I would request a German for the record.
Okay, bench warrant. 10,000, I'll give a 10% privilege. That warrant will issue immediately.
That's in both cases.
That is in both cases.
Thank you.
Court calls the case of the people versus Anton Brooks.
Morning, Your Honor. Raymond Cook.
Arraignment, okay, gotcha. Hello, sir, what's your name?
Anton Brooks.
All right, Mr. Brooks, you're here on an arraignment, on a new charge that alleges that on or about November 27th, 2025, location of 2200 or 2201 Hogback Road to Washington County Jail, that you did commit the offense of an aggravated assault. You understand the nature of what you're charged with?
Yeah.
You understand that? Okay. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court cost. However, a consecutive sentence may be imposed if the assault occurred within a place of confinement like the jail. You understand that, sir?
No, I don't.
Don't understand that?
No.
What part don't you understand?
I didn't really hear what you said.
You didn't understand what I said or hear me? Okay. The maximum penalty is 1 year or $1,000 fine plus court costs. You understand that?
Yeah.
Okay. If it occurred in a place of confinement like a jail,
Yeah.
then the penalty would be consecutive to any other sentence. So let's say you were sentenced on some other charge to say 90 days.
Right.
And this is a year, you could be sentenced to the 90 days and then have to serve a year for the assault.
Okay, yeah.
You understand that? Okay. All right. Now, understanding all of that, the first question I have for you is, do you want to be represented by an attorney on?
Yes, I do.
All right, this is public defender case.
Morning, Your Honor. Assistant Public Defender Constable Basie on behalf of Mr. Anton Brooks, who is present to my right and has stated his name for the record. Your Honor, we would waive further formal readings, stand mute to the charges, request a PR bond and a new pretrial date to obtain discovery, Your Honor.
Well, if he's being held on something you don't want to.
Well, if he's being held on other matters, Your Honor, which looks like he is, we would just ask for a nominal bond.
So my client having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set April 15th. 2026, 9 a.m. Bond in this case. What else are you in on?
Your Honor, he just pleaded, I believe, in circuit court to assault with intent to do great bodily harm as well as concealed carry of a weapon. My understanding is that sentencing on that is set for April 29th. Looking at the notes, it looks like there was a sentence agreement to 1 year in the Washington County Jail, so I expect he's going to be in custody.
Okay. Bond in this case will be set at $5,000. I'll give a 10% privilege on that, although the standard conditions, including no assaultive behavior and no possession of any weapons, firearms, ammunition, or other devices or anything fashioned to be a weapon. Although there are no alcohol, recreational marijuana, or any illegal drugs, I will also indicate that you are not to have contact with Bryant Neal. You understand all of that, sir?
Yes, sir.
All right.
Your Honor, my client is asking for his bond to be lower than the 5,000, 10%. He tells me as part of the agreement, he's due to get out after sentencing. I don't.
Since the 29th, I go back to court and get released. 29th.
You're saying it's going to be
this month.
Right, but you're saying that it's going to be a year credit, a year served?
I already served it.
That's what I mean.
That sentence.
Listen to what I'm saying.
Right.
You're saying that your sentence in that case will be a year, as the prosecutor's indicated, but you've got credit of a year.
Yeah.
All right, I'll leave this where it is. You double check that, and we'll deal with it on the 15th.
Understood.
All right, thank you.
15.
Court calls case People versus Lori Jean Taylor.
Your Honor, Raymond.
Austin Bobes on behalf of Lori Taylor, Your Honor, who's present by Zoom. Ms. Taylor, can you state your full name for the record?
Yes, Lori Taylor.
All right. Yes, Your Honor, today is the date and time for a pre-trial. There has been an offer extended for my client to plead for a civil infraction of double parking. I believe she wants to avail herself of that offer. Is that correct? Ms. Taylor?
Yes, Your Honor.
But we have a problem, same problem as on the other count.
Yes, Your Honor. I have no objection, Your Honor, because that was the offer I was going to make on the case, so it's all going to be resolved one way or another.
Okay.
And just for the record, the packet on is 257.674. Upon successful plea to that and count 2, I move to dismiss count 1.
And that's what you want to do, ma'am?
I'm not sure I understand what he just said.
That they're going to add a count to a double parking, which is a civil infraction. My understanding is that you are going to admit responsibility to that civil infraction. There would be a fine, and then count 1, the misdemeanor offense, would be dismissed.
Okay, yeah, I agree.
Understand that?
Yes, sir.
All right. Is that what you want to do?
Yes, sir.
Okay. And ma'am, do you admit responsibility to the fact that on February 14, 2026, Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
Yes, sir, I do.
Court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180. When can you pay that, ma'am?
Within 30 days.
All right. Pay it then, excuse me, by May 1st.
Yes, sir.
All right. Thank you.
Thank you.
Court calls case of the People versus Christian Bird.
Conrad Sloan on behalf of Peterson Town.
I'm an assistant public defender, Natalie Pate, with on behalf of Ms. Birch coaching. Please state your name for the records, ma'am.
Christian Bird.
All right. What are we doing?
Thank you, Your Honor. So Ms. Bird is not being held on this file, and there is an offer for Mr. Fuller where this case would get dismissed if she was to substantially complete treatment. She is currently being held on her felony case, but release to treatment is in progress on that file, so we're respectfully requesting.
In this courtroom moment, confusion briefly interrupts the hearing as the judge realizes that key paperwork, including the advice of rights form, is missing. The defense asked the court for time to resend the document while explaining that the case may be resolved with a time-served agreement. Meanwhile, the defendant speaks up, saying he wants the court to allow him to go to treatment instead of being placed on a tether monitor, insisting he won't run from the court. The judge pauses the proceedings to sort out the details before making any decision. But here's the question. Should the court allow treatment instead of stricter monitoring?